It is Ask the Judge time once again, and today Judge Courtney Arkeen joins us for one of our most popular segments. Glad to have you again today.
Thank you for having me. I enjoy this.
Okay, now this question, it's one that a viewer has been sending us a few times.
Okay.
It's lengthy, but let's jump right in and see if
Let's
we can tear it apart and get an answer here. If I petition the court in a civil suit in a district court other than the 317th, and I get to the hearing and I'm referred to as a respondent, and the respondent's attorney has opening statements and claims to be the petitioner, is that a misrepresentation of material fact and a fraud upon the court?
Okay, it is lengthy, and I'm going to try to do not so lengthy of an answer, but it does require one. First of all, the person that petitions the court or files the petition is called the petitioner. The respondent or the responding party that is sued or that it's filed against is the respondent. What can happen in a case, though, is then the respondent can counter petition the court, so then they're the respondent and the counter petitioner. Okay, then the petitioner the respondent can also file a countersuit. So it can get very confusing in the titles. In this particular case, the judge, or in any case, the judge will have the court's file in front of them and be able to tell which labels go with which person. In this case, I would guess somebody was just either getting confused or misstating the title that should go with that person, and maybe you should ask the court to instead refer to each party by their names. Then it's a lot clearer, because you can have certain titles and be confused. Call them by their names is what I would say.
Okay.
To answer the question directly, I don't think this is a misstatement of material fact or fraud on the court. That pertains to evidence in a case, not titles of parties.
Okay, wow, that was great. You handled that
to do it
one.
fast.
I know that was the biggest one we've had so far.
Okay.
The second question, can I file a lawsuit because the bingo hall on 11th Street opens the doors of the no smoking area and then leaves them open? I have seen people having heart attacks, choking, and coughing.
Goodness. First, I would obtain the ordinance that pertains to non-smoking in the city of Beaumont. Since it's on 11th Street, that's where I'm guessing it is. Okay. Then this is a situation where a city has to enforce its ordinances. So you would need to file notice with the city and file a complaint and let them enforce their notice. In order to file a lawsuit for civil damages, you have to have that exactly, damages. It doesn't really sound like this person has monetary damages or has suffered any kind of health problems themselves, so it would be tough to prove. I would go the city route, file a complaint, and let the city enforce their ordinance.
Okay, and the third question, what happens if I am in a car accident but I don't have insurance? Can I go to jail?
Well, failure to maintain financial responsibility is a Class C misdemeanor. In theory, you could go to jail, but typically you're not going to if that's the only thing. When a person gets brought to jail on failure to maintain insurance or financial responsibility, it's typically because they have other warrants, and that's just part of the course of conduct. So not typically just on that. You'll usually just get a citation.
Wise to get some insurance, though.
Absolutely.
Okay, well, thank you so much, Judge Arkeen.
Thank you.
And if you have any questions for our Ask the Judge segment, fill out our form at 12newsnow.com/askthejudge. Well, Patrick is back in just a moment with a final check.